So when somebody has lost capacity, there will be a petition filed with the court for a guardianship and a conservatorship proceeding. In the past, in Washington, we just used to call it guardianship. We now call it guardianship, conservatorship. So that's fairly recent. But basically, it means the same thing, that there is somebody who is appointed by the court to manage your affairs. And that could be a family member, or it could be a certified professional guardian, somebody that you've never met before. That person needs to, assuming that you're found to have been incapacitated, and there's this court proceeding where it's determined there's a guardian ad litem, maybe called a friend of the court now, that says, yes, this person needs our assistance, and the court needs to appoint somebody to be the guardian. What they need to do is they need to manage your financial affairs, for example, but they need to file reports with the court because the court is monitoring all of this. They don't have, they don't have the ability to manage your affairs unless the court gives a stamp of approval. Same thing with your personal care plan. The court needs to know what is the plan, and the court needs to approve it. All of this is intended to protect you, which is what the durable powers of attorney were intended to do, but you didn't sign those under this scenario. So you didn't appoint somebody you trust, and because you didn't do that, now the court has to step in and take these actions to protect you. It's all in the court. It is all part of the court's proceedings and records and files. And I can tell you that it is, I'll say, not an inexpensive process. Sometimes people have no money, so there's, it's public pay, but typically if people do have money, then they're paying for all of this from their estate. So it's really a situation to avoid if you can. Can you? Yes, you can. Get an estate plan in place. Get your durable powers of attorney in place. Sometimes we see that hospitals are the ones that are filing for these guardianships and conservatorships because they have to. The person's lost capacity. There's nothing that can be done, and there's none of these necessary powers of attorney in place, so the hospital will file. So it is a necessity when that situation arises. You can avoid this being in a guardianship typically by simply having your durable powers of attorney in place. I failed to mention a healthcare directive. It's also called an advance directive or a living will, and that's also something that sometimes ends up in the court when it's not clear what's appropriate for you. If you are at end of life, do you want heroic measures, or would you prefer none, so that the dying process is not prolonged? That also can be part of a court proceeding. So Washington has an estate plan for you during your lifetime if you lose capacity, and that estate plan is a guardianship and a conservatorship.